Good morning to all of you. Welcome to Law of Torts. Particularly the topic of vicarious liability in the statutory authority, sovereign immunity, sovereign power, discharge of official duty, all these things, non-sovereign function, all these come under only one head, that is statutory authority or vicarious liability of the state towards the employees. So, I have jocularly stated in the class that if you know three Devis, definitely three women in the law of torts, you can successfully complete the examination. That's a practical joke. Please remember. They are State of Rajasthan versus Vidyawati, 1962. Municipal Corporation of Delhi versus Subhagwanti, 1966. And Sushila Devi. Municipal Corporation of Delhi versus Sushila Devi, 1999. And another case, Premvati versus State of Rajasthan, 1977. They all relate to vicarious liability of the state. Let us quickly have a discussion on these cases. State of Rajasthan versus Vidyawati, you all know that on 11/2/1952, when the temporary driver of the collector of Udaipur was driving the vehicle from the mechanic shop and getting it back to the collector's bungalow, it hit Mr. Jagdish Lal, who was coming in the opposite direction on the footpath, and the wife of Jagdish Lal by name Vidyawati and her minor children, they filed a case for compensation against the government of Rajasthan. Government of Rajasthan pleaded that it is the sovereign duty, the driver is in discharge of sovereign power or sovereign duty. But the court said, even the Supreme Court also said, it is vicarious liability because state is bound to compensate. Why? The employee has driven the vehicle in a negligent manner. Sovereign power cannot be accepted because the driver is only in the jeep, not the collector. If the collector had been there, they would have thought otherwise. So the state is liable to pay compensation. That is what is enunciated in Article 300 of the Constitution of India. We have a lot of discussion on sovereign powers in this particular case. Now coming to Municipal Corporation of Delhi versus Subhagwanti, 1966. It is a classic case of the principle of res ipsa loquitur. That means thing speaks itself. Normally, if you want to file a case of tort, you have to secure the witnesses and make them depose in the court of law. But if it is a video, if it is a photograph, then it makes res ipsa loquitur. The photo itself shows what happened. This is what happened in the case of Subhagwanti. The clock tower in the Chandni Chowk, it fell down. At the time, the passers, that is Subhagwanti's husband, Ram Prakash, who was going along the so-called clock tower area, actually due to the inhalation of that calcium powder, which are the debris, he died. And court held that municipal corporations vicariously liable for this death. Then Municipal Corporation of Delhi versus Sushila Devi, 1999. It's a peculiar case where a person going by the side of road, he died because of the fall of a branch of a tree standing on the road. యాక్చువల్లీ రోడ్డు పక్క చెట్టు ఉంది, ఆ చెట్టు కొమ్మ విరిగి ఇతని మీద పడింది. మున్సిపల్ కార్పొరేషన్ వాస్ హెల్డ్ లయబుల్. వెరీ సీరియస్ ఇష్యూ. లాస్ట్ కేస్ ఇస్ పద్మావతి వర్సెస్ స్టేట్ ఆఫ్ రాజస్థాన్, 1977. సో ఇది కూడా ఇందాక మన విద్యావతి కేసు లాంటిదే. ద జీప్ డ్రైవర్ వైల్ గోయింగ్ టు ద గరాజ్, ఆన్ ది వే he gave a lift to a third party. Lift అంటే వాడి ఫ్రెండ్కే ఇచ్చాడు. We can say it for joyride. వాడి ఫ్రెండ్ ఎక్కించుకున్నాడు, ఎక్కిన తర్వాత వాడు నేను డ్రైవ్ చేస్తున్నాడు. యాక్సిడెంట్ టు సమ్ అదర్ పర్సన్స్. Due to the accident, 2 persons died. So, the driver has to pay compensation. Not the government, not the owner of the jeep, because the driver was not allowed to go outside enjoyment. Going spree of outside enjoyment is not in the discharge of duty. So, government is not made liable. సో ఇన్ ద కోర్స్ ఆఫ్ డ్యూటీ ఆర్ డిశ్చార్జ్ ఆఫ్ డ్యూటీ అనే దానికి ఈ కేసులో ఉపయోగపడుతుంది. మిత్రులారా, 4 కేసులు చెప్పాను. గబగబా ఒక్కో దాని గురించి ఒక్కో నిమిషం కూడా రాలా, కానీ మీరు ఆ నిమిషం రాసి పరీక్ష పాస్ అవుతుందంటే కుదరదు. కాబట్టి యూ హ్యావ్ టు మేక్ ఏ నోట్ ఆఫ్ ద కేస్ లా, యూ హ్యావ్ టు రీడ్ ఇట్, యూ హ్యావ్ టు రైట్ ది సినాప్సిస్, దెన్ ఓన్లీ యూ విల్ గెట్ మార్క్స్. ఓకే, విత్ దిస్ ఐఎమ్ కంక్లూడింగ్ ఫ్రమ్ హియర్. థ్యాంక్ యూ.